Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering college panics after $1 million lawsuit for false claim of assault. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. From WTOP News, former University of Maryland student cleared of sexual assault claims, sues school and 2 ex-members of campus advocacy group. And what was that advocacy group? The 2 members held leadership roles in the on-campus preventing sexual assault advocacy group. And from The Nation, I founded Student Activists Against Sexual Assault. A new lawsuit could make my work impossible. A defamation suit against leaders of an anti-sexual assault campus group could allow assailants to weaponize the court system against advocates, which really is holding people accountable for their statements. This is why due process is so important. What's due process? The 14th Amendment's Due Process Clause of the United States Constitution guarantees procedural due process, meaning that the government actors must follow certain procedures before they may deprive a person of a protected life, liberty, or property interest. And also from Title IX for All, the due process provision of the 2020 Title IX regulations were successful. New arguments and data show a continuous need for due process. What do they show? They show that trends in lawsuits by accused students reflect a need for due process. The trend shows the fewer the rights afforded to accused students and the weaker the emphasis on due process by the current presidential administration, which is the Biden administration, the more lawsuits by accused students we see. The reverse is also true. So the more due process you have, the less lawsuits from students who were not treated fairly by the Title IX process at the college. Also now, because of the trend towards defamation lawsuits against false accusers, it means less lawsuits and less liability for people making accusations. Due process serves the accused and the accuser. From WTOP News, former University of Maryland student cleared of sexual assault claims sues school and 2 ex-members of campus advocacy group. A 2.5-year drama has moved from a local campus disciplinary panel to a federal courtroom. It involves a former University of Maryland student accused and later exonerated of a sexual assault accusation who has now filed a civil lawsuit against the school, and 2 Title IX coordinators and 2 former students who were part of a campus sexual assault advocacy group. The suit is asking for a minimum of $1 million in damages. According to the lawsuit, on October 27, 2020, a student referred to in the suit as Jane Roe accused 2 students, including the plaintiff in this case, who uses the pseudonym of John Doe, of sexually assaulting her. After an investigation and a hearing conducted by the University of Maryland's Office of Civil Rights and Sexual Misconduct on September 1, 2021, the hearing officer found that Roe lacked credibility and found that both Doe and his friend, Jacob Poe, were not responsible for the 2 claims that she made according to Doe's suit. The man referred to now as Jacob Poe makes no other appearance in this case. The lawsuit claims members of the campus group tried to ruin his life. The civil lawsuit filed by John Doe claims the 10-month process from the day the accusation was formally made to when he was cleared cost Joe over $100,000 in legal fees. Doe's Virginia-based lawyers, who also represented him in the school's sexual misconduct investigation, have repeatedly declined to comment on the case. The lawsuit claims, even after the university panel cleared Doe, he was repeatedly defamed by 2 former students who are identified as Defendant 2 and Defendant 3 in the lawsuit. Their names were originally part of the lawsuit, but they were granted anonymity by the judge because of the impact this case could have on them professionally. The 2 students are being sued for defamation. Doe alleges in the suit that the 2 students who used to hold leadership roles in the on-campus organization preventing sexual assault, which is recognized by the school, repeatedly called him a sexual assaulter to his friends and classmates despite knowing he was cleared of the sexual assault allegations. He claims in the suit that they undertook a campaign against him to ruin his life at the university and that their continued defamation ultimately caused him to be kicked off the university's club lacrosse team. When first approached last year, a Baltimore County-based firm representing the 2 students pro bono declined to comment. He's now the lead counsel for only Defendant 2 and again declined any comment. Doe also accuses the university as well as Title IX coordinator Grace Carmiol and deputy coordinator Angela Nastasi of allowing the defamation to go on without punishment. His lawsuit says the school violated his Title IX rights by acting with indifference to the harassment he received because he was a male, and says the school also ultimately participated in retaliation against him after he was slandered as a sexual assaulter and then kicked him off his club team. Karamal and Nastasi are accused of violating the Equal Protection Clause of the 14th Amendment in their individual capacities by not investigating his complaints against defendants 2 and 3. Doe claims that show bias towards females and against males. In particular, the lawsuit says Carmiol initially offered to reach out on his behalf to put a stop to what the suit calls the defamatory actions of defendants 2 and 3, but ultimately refused to do anything. The Maryland Office of the Attorney General is representing the university and the Title IX coordinators in the case. The office declined to comment on the lawsuit. The suit claims Rowe, whose 2020 actions first led to Doe being investigated for alleged sexual assault, has continued to publicly harass Doe, including calling him a sexual assaulter, but she's not being sued. The lawsuit says Rowe and her boyfriend confronted Doe outside of a bar in May 2022, and that Rowe's boyfriend attempted to physically assault him. The plaintiff claims he complained to the school's Office of Civil Rights and Sexual Misconduct, but was told the incident did not constitute harassment or retaliation and was dismissed. So why even bring it up? Because it's the school's liability for not following up on a complaint like that. Doe and defendants 2 and 3, the 2 students associated with the campus sexual assault advocacy group, have since graduated from the school. The lawsuit was filed nearly a year ago when all 3 students were still enrolled at the university. Last fall, the attorneys representing the various defendants all filed motions to dismiss the lawsuit, and that motion sat dormant for more than 6 months until a recent hearing. In that hearing, which lasted over an hour, U.S. District Judge Paula Zinnes pushed back hard on the state's arguments, though it was a hearing that also required her to take a viewpoint most favorable to the John Doe plaintiff. In motions filed last August and then repeated in court on Tuesday, an assistant Maryland Attorney General handling the case for the university and its 2 employees argued Doe fails to allege a plausible claim under Title IX and also fails to allege a plausible claim for violation of the Equal Protection Clause of the 14th Amendment. The state has also argued the 2 complaints made against Karamal and Nastasi in their individual capacity should be dismissed because they're entitled to qualified immunity for acting within the scopes of their government employment. Assistant Attorney General Ann Sheridan argued in a filing that John Doe can't factually state that he was discriminated against because of his gender. In her motion, she states, quote, "It's not at all clear that Ms. Rowe and defendants 2 and 3 were motivated by bias against males, as opposed to personal animus against Mr. Rowe or mistaken perceptions about his conduct towards Ms. Rowe when they accused Doe of sexual assault." So maybe they just showed animus against him personally. They just didn't like this guy. It's not his gender that they had a problem with. That's what their defense is trying to argue. The filing went on to argue that Doe alleges no facts that would cause us to plausibly infer he was harassed because he's a man rather than because his harassers believed he assaulted their friend. But the judge is allowing the case to move forward. In court, Sheridan also argued that a ruling in the plaintiff's favor would open the floodgates by allowing anyone exonerated over a Title IX complaint to make similar claims, though Zinnes seemed to be somewhat skeptical of that idea. Sheridan also worried the court could put schools in a difficult position of regulating speech, which constitutionally it can't do. During Tuesday's hearing, Zinnes repeatedly stressed this was a very important case and one that wasn't easy, but she also hinted it may not be a slam dunk case for the plaintiff. At one point, Zinnes seemed skeptical of the allegation that the Title IX office acted with indifference to the plaintiff, by noting the Title IX office at least considered his complaint and that not doing anything about it isn't the same thing as being indifferent to it. In the end, the judge declined to dismiss the case at this point and is allowing discovery to move forward in a way that would reveal more facts before considering any request for summary judgment. So the judge wants to hear more evidence before she makes any other decisions about it. Judge Zinnes also made it clear that she'll closely supervise that process too, warning not to expect a frolic for the plaintiff. She also suggested arguments for qualified immunity for the 2 university employees could still win later in the future. Defendant 2 was also denied her request for dismissal, despite offering evidence she says proves she couldn't have defamed Doe because she wasn't even on campus in the fall of 2021, when at least one of the alleged defamatory comments were said to have occurred. At the time, she was recovering from a medical condition. Her lawyer argued in court that essentially the wrong person was being sued. Ultimately, evidence offered up in discovery could lead the court to remove her from the case if it's proven she wasn't involved. And from thenation.com, I founded Student Activists Against Sexual Assault. A new lawsuit could make my work impossible. A defamation suit against leaders of an anti-sexual assault campus group could allow assailants to weaponize the court system against advocates. In October 2020, a University of Maryland student referred to as Jane Rowe filed a Title IX complaint alleging that she had been sexually assaulted by 2 of her male classmates. In September 2021, University of Maryland found the boys not responsible. So Jane Roe filed her claim. It went through the process. The two boys were not responsible. One of them has filed this lawsuit. And he filed the lawsuit because even after he was found not responsible, after she was found not credible, he was still being defamed on campus for it. It's what happened next that is unusual. One of the accused students, referred to as John Doe, filed a federal lawsuit alleging that two UMD graduates, who at the time occupied leadership positions in the campus student group preventing sexual assault, had defamed him. Doe alleges that students undertook a campaign to ruin his life by calling him a sexual assaulter and stating that he was still under investigation after Jane Roe's Title IX case had been dismissed. Why would they do something like that? I understand if the two students don't like how the case was resolved. Maybe it's a due process issue, but that's not his fault, and he was found not responsible for it. You can't chase him around and tell people on the campus that he's still being investigated when he's not being investigated. The defamation suit is pending, and details relating to it are murky, and most of the relevant documents remain under seal. We have no way of knowing whether the student advocates actually made those statements, and if they did, whether they accurately reflected Doe's actions or evidence drawn from additional investigations about him. What we do know, of course, is the chilling effect that the defamation claim Johnny Depp won against his former wife Amber Heard has had on sexual assault claims. Safe Horizon's Vice President of Domestic Violence Shelters, Kelly Coyne, told MSNBC in reaction to the Depp versus Heard verdict, "We often see clients that face backlash when they come forward. They have to choose which abuse is worse, what is happening in their relationship, or what they will receive when they come forward. Other advocates agree. And the UMD suit is an early indication of how accused assailants could further weaponize the court system, this time against advocates. Defamation suits targeting the accusers in cases of sexual assault are a potent weapon in a broader war against sexual assault survivors and those who seek to support them. Or they're also a potent weapon against people who don't have a legitimate claim, and then it needs to be adjudicated. This is why due process is so necessary in all of these situations. I'm not an attorney and I'm not giving legal advice here. It's just the problem is clearly the due process issue. As defamation suits from alleged perpetrators against their alleged victims multiply, victim support organizations are being forced to rethink their strategies to protect both themselves and survivors. Time's Up Legal Defense Fund reported to The Intercept that since 2018, it has awarded 62 grants to deal specifically with victims who fall prey to defamation suits. According to a survey by Know Your Nine, a survivor justice legal advocacy group that supports students, 23% of student survivors said either the person they accused of assault or that person's attorney threatened to sue them for defamation. 19% said they were warned by their school of the possibility of a defamation suit, and 10% have faced retaliatory complaints filed by their assailants. Jezebel reported on an increasing number of successful anti-male bias lawsuits in response to disciplinary action related to campus sexual assaults. Meanwhile, the Connecticut Supreme Court ruled 7-0 that a former student at Yale could be sued for defamation based on the allegations of sexual assault that she made to campus administrators. The court ruled that unlike the immunity that survivors are granted for allegations made in a criminal prosecution, a survivor's Title IX accusations are not protected because the accused has fewer rights. This ruling, like the Depp verdict, will reinforce the message that survivors hear from the culture at large, that it's often not worth facing the emotional distress and sexualized character assaults that await most victims of assault who come forward to name their assailants. Combined with the impact of the Connecticut case, the pending Maryland lawsuit may represent a new fiercely repressive age in the struggle to report and process legitimate claims of sexual assault. Soon it may not only be the victims themselves who are legally and financially vulnerable, depending on the outcome of the Maryland suit. Advocates seeking to lend support to survivors could face lawsuits too. Yeah, if those advocates are out there telling people that the accused actually is guilty, especially after being adjudicated as not guilty or not responsible after a Title IX proceeding, and the advocates decide they don't like that result, so they're out there telling people, no, he's still under investigation. This person is still under investigation. They're guilty. They're an assaulter. You can't do that. If you do that, yeah, you could get sued over it. When educational institutions and criminal courts fail to provide meaningful protection, where can students turn? Student-run advocacy organizations are the only university-affiliated groups that prioritize the protection of survivors without the conflict of a mandate to protect the university's reputation. So the real question raised in cases like the one at UMD is whether such advocacy can exist at all at university campuses, or whether student advocates will be too afraid of their legal exposure. What would student advocacy groups look like without the right to defend the victims those advocates claim to represent? Will students be deterred from campus advocacy when it could well threaten their own prospects and financial well-being? How might this case disrupt the pipeline of experienced activists who will later become lawyers and activists in this field? But you have to be responsible. Even as a student, you're a young adult. You have to be careful about what you say and do and how it could affect the reputation of people, especially in a Title IX situation where you don't have the full rights that you have in a criminal process. When people are reasonable, you don't need to create strict guidelines and limitations for what is and what's not reasonable. Everyone kind of has a common understanding culturally of, okay, I can do this, but I can't really do that. It does seem like with all of the culture war activity going on, with the left attacking traditional culture, the concept of the Me Too movement, which completely removes the concept of due process, that an accusation is enough to consider somebody guilty, the idea of removing innocent before proven guilty from our culture, whether it's in college or in mainstream society, doesn't really make any sense. It's not good for accusers. It's not good for the accused. Within our system of laws, we do have due process to test people's accusations and claims. We have to have a process that respects the rule of law. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up, and I'll see you again soon with another video. And if I don't see you, I will miss you.